And we're back with part 3 of the first human rights lecture for TRIB 2303. I just left you at the end of the last one with some definitions. So one of those definitions that we touched upon was an exemption. Again, quote from your textbook, where an exemption is when one person or body or entity is not bound to fulfill an obligation or a requirement that others must observe. So first of all, section 11 of the code, and if you have a code in front of you, you can flip to that. That outlines exemptions to discriminatory practices. So in other words, when some discrimination is acceptable, even in an area that is otherwise protected by the code. So those exemptions will be allowed if it is reasonable and bona fide in the circumstances. What's bona fide mean? It essentially means it's in good faith and it's justified. Depending on the circumstances of the situation, all right? So that's a Latin term, bona fide, B-O-N-A-F-I-D-E. So section 11 of the code, which provides for exemptions, essentially allows for some differential treatment to occur. And what are those areas that it allows for? We know that age is a protected ground under the code. It applies specifically to the ages of 18 to 65. Also 16 and plus, so age 16 and 17 in the area of housing, right? If somebody's estranged from their guardian. And you hopefully know that at this stage, or hopefully that those dots are connecting for you, because that forms the basis of your scenario for your Human Rights Tribunal advocacy assignment. Otherwise, aside from that exemption for housing, which also includes, or I should say exception, which also includes ages 16 and 17, code discrimination on age can only be between the ages of 18 and 65 to claim that ground, okay? Age discrimination is therefore allowed in the insurance industry, specifically for rates that are provided for individuals over the age of 65. Another exemption that the code allows is gender and race discrimination in the area of housing. This would be if the owner or a family member lives on the premises and they'll be sharing a kitchen or bathroom with the prospective tenant. Then in that case, they are allowed to put restrictions on if I'm female, that I only want a female tenant living with me or sharing my kitchen and bathroom with me, because the unit is that, we're living in that close quarters in the unit that I'm renting out, okay? Of course, not so much an exemption outlined in the Act, but the Human Rights Tribunal of Ontario does not have jurisdiction to deal with a matter that is better left to the Canadian Human Rights Tribunal, because it deals with a federal entity, okay, under federal jurisdiction. All right, so then this is where we start talking about the applications and the responses. And I just wanted to point out a couple of key points for you as you start preparing this, because for your Human Rights Tribunal Advocacy Assignment, Part A1, you need to provide the application as well as a supplemental form. Both are on DC Connect for you to download so that you have the right one, and the response. So all groups will be completing both the application along with the supplemental form and the response. The Human Rights Tribunal has to receive both the application and the form in order to start pursuing that, okay? The application must be submitted within 1 year from the date of the last occurrence of the discrimination. It can be submitted electronically, by mail, by email, and by fax. And there is no filing fee. So this is something different than we've seen at other tribunals. Typically there's a filing fee, whether it's minimal like $50, as some of the forms allow for at the Landlord and Tenant Board, or perhaps more significant like $300 that we see at the LPAT. No filing fee, and that's to ensure that nobody is, I guess, prejudiced or left out of the availability or accessibility to justice, right, in the area of human rights. Once the application is received and served on the respondent, the response must be submitted to the Human Rights Tribunal within 35 days. The response is completed on a Form 2. If the response is not complete, the Human Rights Tribunal will return it with an explanation and give the respondent an additional 20 days to complete their response. Okay? And then a copy has to be sent to the applicant as well. So we're going to talk about some application specifics and some response specifics, and I'm hoping to get through both of these in about 5 or 6 minutes, just with some of the key factors that I wanted to point out to you, okay? Application specifics, you need to include the contact info, including an email. If you include an email, you are consenting to email delivery of documents. All right? You will name the individual as well as any organizational respondents. It's a good idea to bear in mind who those organizational respondents might be, if any. And that's because typically the organizations are the ones that have deeper pockets. So if you are looking for a monetary award, organizations sometimes are able to, they just have the wherewithal, the financial ability to provide a monetary award easier than an individual would. So if an organization could possibly be named, it's something to consider for sure. There is also a practice direction on naming respondents that is available on the Human Rights Tribunal website. So I would refer you to that if you have some questions in your assignment or just in general, okay? There are very specific instructions on naming the Ontario government as a respondent. So you can pay attention to that. That also comes up in the rules and in the practice direction. You then need to identify the grounds of discrimination or harassment upon which your application is based, and multiple grounds may be appropriate. For example, if you, and this comes directly out of the Human Rights Tribunal directions on completing applications, if you are applying to the tribunal because you feel like you've been discriminated against and you are a woman of African descent, you might actually, on your grounds of discrimination, check off race, color, ancestry, and sex. Those are 4 different grounds that could apply to your scenario, your situation, your life, okay? So it's very possible to have multiple grounds of discrimination. If a ground is not there, you cannot create it. I know that sounds probably obvious to you, but this is very clear in the Human Rights Tribunal guidelines that they put out. And I suspect it's written so clearly because people have tried to create their own grounds of discrimination. So you can only stick to the grounds that are listed and identified under the code as being acceptable sort of grounds to bring a discrimination claim before the tribunal, okay? And then you also need to identify the social area as well. Employment, housing, goods, services, facilities, contracts, or membership. And there's a different supplemental form for each one of those code social areas. Because we're dealing with housing in our advocacy assignment, you'll be dealing with a supplemental form for housing, which is 1B. Then you need to provide your facts. What are the facts that are supporting your application? You need to be specific. So, do the events happen in Ontario? In what city and what town did they happen? What was the date of the last event? And that's important because of that 1-year limitation period for filing, right? And then what happened? Exactly. Who was involved? When did it happen? Where did it happen? You want to give specifics here. You don't want to just be vague, okay? You need to lay out your story. Lay out your arguments. It's best idea also to give a chronological account of what happened. That makes it so much easier for the person who's reading the application, even the respondent, to understand what your version of the events is, right? What your theory of the case is essentially. Okay, let's move on here then. A few other things in the application to be aware of or to look for as you're completing it for your assignments. What was the effect of the alleged discrimination or harassment on the applicant? Was there a financial impact, a social impact, emotional impact, mental health? All of those are factors that the tribunal wants to know about and wants to consider when they're making their decision. What remedy is the applicant seeking then? Is there a monetary remedy? So for example, did the applicant lose money of some sort? Okay. Were they forced to spend money out of pocket because of some discrimination that happened? So they're looking for those costs to be returned to them. Injury to your dignity and feelings can be included here as well. Non-monetary remedies are also acceptable. So something that might put the applicant back in the position they would have been prior to that discriminatory treatment occurring. So this is non-monetary, okay? So for example, were they let go of or from a job on the basis of some sort of grounds of discrimination? If so, should they be receiving their job back? Okay, that would be a non-monetary remedy. And then future compliance, it's a completely different remedy scope that we haven't really talked about in any of our other tribunals so far. But this is an action that the employer is ordered to take, so that the tribunal can put this requirement almost like a specific performance, right? Almost like the concept of equitable remedy. What is something that a tribunal can order an employer to do or order them to stop doing to prevent future discrimination? Must they adopt a new policy, for example? These are all examples of remedies that you can request in your application to the Human Rights Tribunal. You will need to identify if the applicant agrees to mediation, and we'll come back to that in our slides for next week, as well as are there any other related civil proceedings. What documents exist, what documents are in your possession, meaning the applicant's possession, what documents are in the respondent's possession. Maybe you wrote a letter. In this day and age, usually that's done over text or email, and so we have a copy of it, but maybe you didn't. Maybe you hand wrote a letter. And so do they have a copy of something that you actually need that's important to your case? So you would state that there. Or are there documents in a third party's possession? Then you're also going to identify who the witnesses will be and what they will say. Why is it important? Okay? Once the application is received, the application is assigned a file number by the tribunal. Then it goes through a completeness review. Is the document complete? Essentially, it will go through a jurisdiction review. Is this in the area of the tribunal as per the code? So does it cover a code ground? Is it in federal jurisdiction, which would be outside of the area? All of those things, okay? Excuse me, there might be a summary hearing review that would be required if there is no reasonable prospect of success. Okay, so for example, is the application showing signs of being frivolous or vexatious? Once all of that is completed and it looks like it can proceed, then it will be delivered to the respondent. And then as already mentioned to you in this video, the respondent has 35 days from receiving that application to file their response with the Human Rights Tribunal. Okay? Okay, so we're going to again pause this video here, and then we're going to turn to response specifics, what needs to be in the response, and just a couple of clarification matters for your Human Rights Tribunal advocacy assignment going forward for this week and next. Talk soon.